Good evening, everyone. Ben Lombard, Underdogs versus Discovery. Thank you for watching our videos. Without your support, I'm pretty sure we would not have been so encouraged to proceed and push ahead. We will talk about that later, but thank you for watching. Tonight, I am going to be dealing with some correspondence received during the past week, last week, past few days. I'm going to be reading that out to you. The first one is a letter that I received on the 1st of September. It is addressed to me by Mr. George van Wyk / Darren Swartz from Edward Nathan Sonnenberg, ENS abbreviation, and this is what it reads. Dear Mr. Lombard, attempted misinformation and defamation campaign. We represent Discovery Life and write to you regarding the recent correspondence, most pertinently your ongoing public campaign styled Underdogs versus Discovery. It is self-evident that your recent public posts are aimed at advancing a negative and inaccurate account of your dispute with Discovery Life, and while we understand that when a claim is declined, this can be deeply upsetting, it remains important that any public statements must be accurate, factual, and honest. Your posts on LinkedIn, Facebook, YouTube, and other platforms contain statements that are factually incorrect, misleading, unjustifiably damaging to our client's reputation, and constitute defamation under applicable laws. You have selectively disclosed information to misleadingly suggest that Discovery Life deny claims which are valid. This is demonstrably untrue. To illustrate this point, we record the background briefly. You submitted a claim under severe illness benefit in your insurance policy in 2005. The claim was declined by our client because the timing of myocardial infarction, silent heart attack in brackets, which you suffered could not be established to have occurred after your policy inception date, and insufficient medical information was available to support the objective determination of the severity of your condition. In 2016, you referred the matter to the Ombudsman for Long-Term Insurance after an independent review by Dr. Kutzer. The Ombudsman upheld our client's decision in 2017. This is the following extract. It's very fine print, so I have to just read it nice and clear and get some light on it. This is the following extract from Dr. Kutzer's report as pertinent. Did the event take place whilst cover was in force? The date of the infarction is undeterminable, as pathological Q waves will remain present on ECG permanently, and it stands to reason that any insurance contract, whether that is short or long-term insurance, only covers claims events that take place whilst the cover is in force. Most contracts do specify that explicitly, and I would be surprised if Discovery's contract does not contain such a proviso. And even if it is not specified in the contract, it is still implied. It cannot be reasonable to expect the insurer to pay for a previous event if there is a significant probability that the event could have preceded the inception of the policy. The claimant argues that the onus is not on him to prove the date of the infarction. This is incorrect. The claimant must prove that he has met the contractual criteria that benefit the event, and this includes proving that the event took place. Sorry, that's what it says there. When cover was in force. Conclusion. Taking all the facts into consideration, I have to conclude the following. Number 1, the client did suffer a heart attack. Number 2, it regionally meets the contractual definition of a level C severity. It has not been proven that the infarction took place whilst cover was in force. This means that I support Discovery Life's decision to repudiate the claim. Right. This is a Dr. Kutzer that put this together. Right. The conclusion is clear and unambiguously supportive of Discovery Life's decision to repudiate your claim based on the inability to establish whether the silent heart attack occurred while your policy was in force. You have not provided any new medical evidence in the intervening period calling on our client to review the decision or that could impugn the Ombudsman ruling. Instead, nearly 2 decades after the event, you have embarked on a campaign of misinformation and defamation in the public domain. While our client fully respects your rights to speak out about your experience, your portrayal is not supported by the facts and is deliberately attempting to damage the reputation of our client's business. You have further incited and tried to encourage other individuals to contribute to misinformation being spread without verification of the facts. Furthermore, your public allegations of harassment and bullying, as well as claims that is owed to you, are false, and your threats to individuals employed by our client are not only unwarranted, but unlawful. Accordingly, you are immediately to cease with any defamatory, inaccurate, or misleading statements concerning our client and its employees. Remove all defamatory content published by you or at your instance with reference to which references our client's correction, its subsidiaries, or any of its employees. Refrain from any direct or indirect communication with our client's employees other than through our offices. Separately, we have independently reviewed the video recording of a meeting to which Ms. Lindy Smith refers in your recent interview. The assertion by Ms. Smith that she was bullied, not given a chance to speak, and told she does not have the money to litigate is blatantly false. We invite you to view the recording of a meeting, in brackets, subject to Ms. Smith's permission, to verify the foregoing, and once again remind you of your legal obligation to verify the information being published on your platforms. Our client wishes to stress that they welcome general consumer feedback and have no intention to curtail public comments that you may make, including the publication of this letter. However, any publication should be complete, transparent, and fully represent the facts, true facts. In conclusion, we sincerely hope that you consider your approach. Should you fail to do so and persist with your unlawful conduct, our client reserves the right to take such further action as it may be advised to protect its rights. All our clients' rights are strictly reserved. Yours faithfully, Edward Nathan Sonnenberg, per George van Niekerk / Darren Swartz. On this letter, I must first mention that it says that I must stop. We are. Refrain from any direct or indirect communication, and also that furthermore, there we go. Let's put that one out of the way. So, I took upon myself to clarify that. I received that letter from Mr. Van der Kerk. I responded cordially. This is my response to Mr. Gore. Same day. Dear Mr. Gore, I acknowledge receipt of your letter dated 1st of September sent on behalf of Discovery Life Limited by ENS Africa. I have reviewed its contents carefully. The correspondence sets out the position of Underdogs versus Discovery and highlights urgent matters requiring immediate attention. Number 1, right to commentary. I reserve the right to communicate my experiences regarding my life insurance claim and my interactions with Discovery Life. My statements are factual, supported by official records, and made in the interest of transparency, accountability, and lawful disclosure. Should these matters remain unresolved, I am prepared to place the verified facts in the public domain. Number 2, factual background. My severe illness benefit claim lodged in 2005 was wrongfully declined. In 2017, the Ombudsman confirmed Discovery's decision but did not preclude further lawful scrutiny. Medical consensus has since established that I have suffered a silent myocardial infarction in brackets mild heart attack. All my statements to date remain accurate, factual, and verifiable. Number 3, conflict of interest. Of particular concern is the role of Mr. Hein Himan, Discovery's head of legal matters, who also served on the Board of Trustees of the Ombudsman for Long-Term Insurance at the very time I made my second attempt to resolve this matter in 2017. The dual role created, at the very least, the perception of a serious conflict of interest. It raises fundamental questions about whether my case was ever afforded and the impartial and independent consideration that it rightfully deserved. I'm addressing you directly because I believe that open dialogue between us is essential, not only to resolve my claim fairly, but also to strengthen the system for the benefit of all Discovery holders. Number 4, legal onus. Established precedent. South African law is clear. The onus rests on Discovery to disprove a claim, not on the insured to prove the exact timing of the heart attack. Relevant precedents include Mutual and Federal Insurance Company Limited versus Oudtshoorn Municipality, and there's also the NVSO-SA case CR244. Very, very prominent case law that has been drastically overlooked in my case. On this basis, Discovery bears a legal duty to substantiate any denial of my claim. Number 5, non-negotiable settlement. The full settlement of my claim, including compound interest, accrued since 2005, is non-negotiable. Discovery had a second opportunity in 2017 to correct its error and failed to do so. As an experienced professional in long-term insurance, you are well aware that there is no legal basis to continue repudiating this claim. Any further attempt will expose Discovery to heightened legal and reputational consequences. Criminal prosecution route. The Underdogs will not pursue litigation or further ombudsman intervention. The remaining lawful avenue is criminal prosecution. This will bring to light Discovery's malified conduct and will proceed through the Commercial Crimes Court. Prosecution will be conducted by the state at no cost to the Underdogs. Mediation and negotiation mandate. I have been mandated to negotiate on behalf of the underdogs. I am prepared to mediate outstanding claims objectively in the best interest of all parties. Number 8. Removal of Hein Heman, non-negotiable. Consensus has been reached that Mr. Hein Heman, head of legal matters at Discovery, must be removed immediately. This is a non-negotiable demand. Failure to act will escalate this matter into full-scale public and legal campaign. Should you, Mr. Rian van Rijn or Mr. Hein Heman, fail to address this, you will expose yourselves directly to prosecution and reputational harm. Number 9. Immediate action required. To resolve this matter constructively, the following actions must be taken without delay. Release audio recording of a meeting with Ms. Lindy Smith once written authorization is received, which is what Mr. Lindy Smith did. She sent it immediately. And arrange for a personal meeting with me at a mutually convenient time. Settle my claim in full with all accrued interest. Remove Mr. Hein Heman from this position without delay. This correspondence demonstrates both my willingness to engage responsibly and my determination to hold Discovery accountable. Mr. Gore, I trust that you will recognize that this is not only about my personal claim, but about the broader duty of Discovery to uphold fairness, transparency, and the confidence of its policyholders. The seriousness of these matters requires immediate and decisive action, and I expect confirmation of your commitment to the above points without further delay. Sincerely, Ben Lombard. Follow up on that, I received a letter from Mr. Van der Kerk, who seemed not happy about the fact that I am now addressing the letter to Mr. Gore direct. In essence, he warned me about that. I explained it to him that it was not my intention to sidestep him, but to keep Mr. Gore in the loop of what was happening. So here's my letter that I replied to. Here we go. Dear Mr. Van der Kerk, I acknowledge receipt of your correspondence dated the 2nd of September 2025. For the avoidance of doubt, my inclusion of Mr. Adrian Gore in a copy is not an attempt to circumvent your offices, but to ensure that the Chief Executive of Discovery Life is fully aware of the seriousness and gravity of this matter. Transparency at the highest level is both reasonable and necessary. I confirm that I will not engage in direct communication with Discovery employees outside your office, save where lawful public commentary or disclosure rights apply. I further remind you that I've already requested my documents in terms of the prescribed Form C submitted to Discovery last week. No, that's the week before this. I now formally request that these documents be delivered to me in person without further delay. Additionally, you have offered to make the audio recordings of Ms. Lindy Smith available to me. Ms. Smith has already sent an email to you requesting that these documents and recordings be made available for my personal information. I hereby reiterate my request that they be provided without further delay. My previous correspondence out clear, evidence-based issues which remain unaddressed. The core matters of my settlement, the role of Mr. Hein Himman, and Discovery's accountability to policyholders demand substantive engagement, not procedural deflection. I reaffirm my commitment to have this matter remedied and resolved amicably. I trust Discovery recognizes the seriousness of these matters and will respond accordingly. I look forward to the confirmation that these outstanding issues will be addressed constructively and without delay. Sincerely, Ben Lombard. Subsequent to that, I received another one. Let's see where that one is. Oh, here it is, yes. Then Mr. Van Niekerk responded, Mr. Lombard, I acknowledge receipt of your email, which in terms disregards a very specific request of paragraph 6.3 to refrain from any direct or indirect communication with our client's employees, other than through our offices. I have noted the counter demands in paragraph 9 of your email. The matter must now take its course. Sincerely. So I fully realize that the matter is going to take its course. I have tried my best in the interest of everyone. Now, Mr. Gore, Mr. Adrian Gore, now I have to address you, sir. Mr. Gore, I fully realize the impact of these allegations of mine if they are found to be unfounded. My claim is procedurally and elementary substantiated, and furthermore, if it was an oversight not to settle my claim in 2005, it certainly was done with far more information to your disposal or at your disposal in 2017. The same reports that my cardiologist provided in 2005 were used in 2017 as well. So to say more information was given is not actually correct. It's the same evidence was given and also supported further. With regards to that, there is no reason. It is now in a public domain. There is no reason for you still not to want to settle my claim. As I said in the letter to you, that is a non-negotiable matter. As I said in the letter, we are not going to spend endless times on litigation and ombudsman. And now, based on the fact that the ombudsman, that Mr. Hein Himman was also part of a board of trustees in 2017, when my claim was repudiated, raises a very strong suspicion. It's been almost a week since I've requested my documents. I have indicated that we are proceeding with criminal charges. All the underdogs have submitted requests for the documentation to be provided, and it's being withheld from us. That is not going to stop us from proceeding with the criminal cases, Mr. Gore. I was hoping to avoid all of this by talking to you and addressing you direct. It seems like it's not going to happen. So I have no option but to go and address my concerns in the open social media. I also understand that one of the other underdogs has been sued. There's litigation going for defamation for a 10 million rand defamation of character. Now, Mr. Gore, right up to now, all I have been doing is I have been reporting factual. I have checked out the other videos that I've made before I made them with regards to Ms. Lindy Smith, Mr. Lloyd White, Ms. Annie Barty, and then also Mr. Elmer White, lots. I have no reason to believe that any part of those are false. In the case of Mr. Elmer Lots, the meeting the virtual meeting was held between him and Hein Himmel, and one other gentleman whom I am made to believe to have been Mr. Stephen Chatz. During that meeting, Mr. Lotz's, not only his attorney, but his advocate were also present. And I'm going to find it very difficult to believe that any of those men of their stature would want to lie about it. So it isn't a public domain, Mr. Gore. I am proceeding with the criminal case. Mine will be very elementary, and unfortunately there is no litigation involved, there's no ombudsman involved. I'm going to give you your own opportunity and those others implicated in my claim to answer in an open court. And I am very confident that I have a prima facie case in this matter, and I am definitely proceeding with or without your documents. Obviously, those documents can be obtained once a Section 205 warrant has been issued, which I have no doubt will be the case. I am still open to discussion, Mr. Gore. I am still open to discuss my case and the other dogs. I do fully appreciate that I will not be able to save the entire world, but the underdogs as it is there, collectively, it's only 10 of us. Mr. Gore, 10 underdogs with a collective claim outstanding amounting to R1 billion. This is the tip of the iceberg. We can still fix. I would not want to see the shareholders suffer. I would not want to see management suffer. I would not want to see employees suffer, and I would not want to see policyholders suffer anymore. I stand by what I've said, and if I had said anything before today that was so defamatory, you definitely would have made sure that a court interdict be obtained and served upon me. So there it is. It is now out in the public domain. Somebody is going to get hurt, Mr. Gore. These underdogs have been hurt for too long. It's hurtful to see them. It's hurtful to see how they suffer. I don't only speak for me. I speak for every underdog out there. I trust that you will take this opportunity to engage with me in person, in dialogue. I am open to discussions. My claim is not negotiable and remains non-negotiable, but I have the mandate of the other underdogs to negotiate settlements on their behalf. So here we go. Thank you very much. Mr. Gore, you have my cell phone number, I have yours. I'm not going to call you because here we have something that says. So please don't phone from a landline. Phone me from your cell phone number so I can recognize it's you, and I'll be dealing with it. Thank you very much for listening and watching, everyone. And this is, let us hope that we can bring this to an end. And Mr. Gore, just to say to you, this is not defamation. Ben Lombard will go down in history as being the whistleblower in the Discovery Gate saga. Thank you, everyone. Mr. Gore, I fully understand and recognize the power that you have, not only in political circles, but also in the business sector. But I must emphasize the fact that no person is above the law. I believe that you have a case to answer to. I have received a lot of support from all over. We have the Government of National Unity that can become involved. We also have the non-profit organizations that are also fighting corruption in this country. I believe this is a matter of national interest. It can be resolved, and it can be resolved very quickly. I have no intention of, as I said, going beyond Underdogs versus Discovery. The 10 of us, I speak on behalf of all of them. I'm not excluding taking the matter further than that. This is not a threat, Mr. Gore. It is definitely beyond me to make threats like that or try to extort anybody. And I believe that the time has come for you to approach me direct, and we see where we go from there. In the interest of all your shareholders, in the interest of all your employees, in the interest of all your management, in the interest of all your policy holders, let's make it right.